you see, my title says the appropriate dispute resolution, and I'll explain why. I'll just go through a quick, brief introduction, and then I'm going to talk to you a little bit about the fundamentals of appropriate dispute resolution, then go into arbitration. Now, both the part about arbitration and effective arbitration clauses are just very basics, you know, and I hope it helps you understand and appreciate what arbitration does, exactly like what the Honorable Justice had mentioned about being a concrete, transparent system that's confidential and can be an alternative. In your words, it'll be an alternative to going to court. All right. So now, I'd start off with this, that a culture of dispute resolution, people of different religions. This is Kofi Annan, the then Secretary General of the United Nations, had said this. People of different religion and culture live side by side in almost every part of the world, and most of us have overlapping identities which unite us in every very different group. We can love what we are without hating what and who we are not. We can thrive in our own traditions, even as we learn from others and come to respect their teachings. And this is exactly what I think the exercise Johnson is going through with this 50 hours training, is for you to appreciate that there are differences and there are different ways of dealing with disputes, right? So keep that in mind. In India, I thought not something I need to teach you, but you know, or share with you, but the ancient practice of panchayat is a clear example of how appropriate dispute resolution culture works in India. Right? And interestingly, Mahatma Gandhi had advocated portions of this in the Constitution 73rd Amendment. If you take a look at that, you'll see about how disputes can be resolved in a more amicable way. Right? In China, the philosophy of Confucius teaching is a well-known ancient system of thought and behavior, stressing the virtues of compromise, yielding and combine to create pressures and institutions for extrajudicial mediation. So you see, even then, you had not just or not necessarily going to court for the matter to be tried in court by a judge, but methods that can allow parties to make compromises, right? Now, 2 years ago, I think, in July 2021, the Chief Justice had, in his keynote address in Singapore, it was an Indo-Singapore Mediation Summit, and he said, you know, that there was the number of cases that the Indian courts were facing. Conflicts were unavoidable in any society, and he stressed that with conflicts there are also the need to develop mechanisms of conflict resolution, referring to, for example, referring to a grassroots method that you have in India. And he said, you know, you have to look at alternatives. Again, we come back to the word alternatives, but as I mentioned to you, I will lead you to appreciating why it is more looking at it as appropriate dispute resolution. Okay, so with that, let me just take you to the fundamentals of appropriate dispute resolution. Now, with this, I just want you to appreciate that even a lot of practitioners, legal practitioners, are not so familiar about the different methods of dispute resolution. And I thought this paper or this keynote address would keep the context and let you know and understand exactly where arbitration falls within the whole regime of dispute resolution. And some of you may be familiar with some of these, but some of you may not be familiar with it. But let me just start. The first two aspects that you need to appreciate is that there's one that's consensual. That means there's one that's parties have control over the process to reach a mutually beneficial settlement agreement, with third parties sometimes facilitating, right? So that's more of a consensual in the sense that it is between the parties that settle, okay? And and I'll show you some of these, but opposing this consensual is something called adjudicative, and we'll come to that in a minute, in a couple of minutes as well. So the first of the consensual that I'd like to quickly address is conciliation. It's a process whereby the parties to dispute use a conciliator, akin to a negotiator, who plays a direct and central role. It's kind of an authority figure with the parties both together and separately, meeting the parties both together and separately to try and have them resolve their matter. And this conciliator would encourage communication, review the issues, encourage parties to look at options and so on. Okay, in your arbitration, the Indian Arbitration and Conciliation Act of 1996, it expels out Section 67 spells out the role of conciliator. So when you have a time, if you click on just this part where it says Arbitration and Conciliation Act, it will take you to the act, right? So my presentation, when it's sent out to you, would have hyperlinks that will direct you, and you can take a look and read that in your own time as well. Okay, now some of the other aspects of the conciliation part is how it's how conciliation applies, how you commence the process, the number of appointment of conciliators, suggestions by parties for settlement, settlement agreement, termination of the conciliation process, and so on and so forth. Now, I like this because you have a very clear, under an act that provides a regime for conciliation. Whereas in many other countries around the world, when you talk about conciliation and negotiation, it's not a structured fashion. It's not structured in the kind of formalities that you have here. So what you have in India and the Act and what the Act provides is really quite beneficial for, if you think about trying to resolve your disputes without going to court or without having to turn to arbitration. Okay. The next consensual method that I like to highlight is negotiations. Right. It's a bargaining process through which parties attempt to forge an agreement to resolve disputes, but sometimes also dealing with agreements, entering into an agreement, establish a business contact and keep that relationship going. And it's often described as an interpersonal decision-making process that is necessary whenever we cannot achieve our objectives single-handedly. So you see, we're now still on this part of consensual, and it's between the parties. The two parties come together and try and negotiate a deal or a settlement. Okay. The next that many of you may be familiar with and has been a buzzword for the last couple of years is mediation. Right. A mediation is a voluntary process involving a neutral third party, a mediator, who facilitates the disputing parties to reach a settlement. But this mediator, unlike the conciliator, doesn't give opinions, doesn't make recommendations, doesn't share his views on the matter. He just facilitates the party coming to a resolution. And that's what mediation is. It's very different from conciliation. All right. Now, many of you may know or may not know about the Singapore Convention, but when take a look at it when you have the paper sent out to you, it provides the Singapore Convention on Mediation provides an enforcement mechanism for internationally settled mediations, right? But it has to be an internationally settled mediation, which means the parties to this mediation, one party may be a foreigner, but they all come together, have their matter mediated, and it's settled. But if one party then refuses to pay on that settlement, there is an enforcement mechanism, and it's called the Singapore Convention. Johnson briefly mentioned to you that in arbitration, you've got something called the New York Convention. When you're taught about it, and in my paper, I do speak a little bit about that, it gives you an idea that it makes dispute resolution mechanisms like mediation and arbitration really kind of enforceable. You know, to some people, they look at it as though that there's a little bit more, it's binding in nature, right? As opposed to some of the others that, like, for example, I mentioned to you conciliation, negotiation. Your question that you might have is it binding? We'll talk about that maybe when we get to question and answers after my presentation. But I just want you to appreciate that in mediation, because of the Singapore Convention, there is that enforceability if one party does default. Okay. There are a couple of other things in the Singapore Convention, what it does, but I'd rather you take a look at it at your own time, and let me go on to the next. Now that I've spoken about the consensual approach, conciliation, negotiations, and mediation, let's go now to an adjudicative mechanism. Right now, this word adjudicative, I just like to highlight that, you know, if you were in America, everything is adjudication, whether it's crime, whether it's criminal, whether it's a criminal matter, whether it's a family matter, whether it's a civil matter, whether it's a commercial matter, it's adjudicated at the end of the day. So if you speak or use the word adjudicate, in your discussions with an American lawyer or American party, it is all encompassing. But in my presentation, what I'm highlighting is that adjudicative mechanism of dispute resolution is where an independent, neutral, independent third party who has the authority and makes a decision in the matter. So it is not in your hands. It is not within the party's hands to decide, but a third party makes a decision. So therein lies this very critical difference from the consensual approach where you have conciliation, negotiations, and mediation. It's all about you parties coming to a settlement. Whereas in an adjudicative method, it is third party coming to a decision. Now, most of you, I assume, are familiar with the most commonly used adjudicative method, going to court, litigating in court. That's what everybody knows. But I'm just going to showcase to you in the next 10 to 15 minutes or so that there are several other methods of a third party making a decision which does not require you to fighting it out in court. All right. The first of this is neutral evaluation, right? It is exactly what the word says, neutral evaluation. A neutral party makes an evaluation, right? And it's very often this neutral third party, this neutral is either a former judge or a senior counsel who hears and reviews written submissions between the parties and considers the legal merits and provides a reasoned opinion, right? Now, why do you turn to a former judge or a senior counsel? Because they would have gone through litigation and they would be able to tell you or guide you as to who or who is likely to succeed at the end of the day in trial. All right, so it's very important that you get someone senior enough who can appreciate these things. Now, the merits of each case and the changes of success at trial, the chances of success at trial are all discussed by this neutral. Now, the next method that I want to quickly highlight to you is what is called expert determination. Now, in an expert determination, what happens is that you get an expert on board, right? Why do you need an expert? Now, please remember, a judge, a senior judge, or a senior lawyer is not an expert, right? They may be an expert legally, but they may not be an expert in a dispute. So, for example, if you have a construction dispute, you want an expert, maybe an architect, maybe a quantity surveyor, maybe a civil engineer, are experts, right? And he can make a determination on the kind of problems you have. So let's say you have a banking dispute, and you need an expert because it's on the technical aspects. It's not on the facts of the case, right? Then what you need is a banking specialist to come on board and tell you technically how the matter would, and give a determination at the end of the day that I determine this is what it is, all right? So that's what expert determination does. Next, you have what is called dispute boards, right? A board of impartial professionals formed contractually at the beginning of the project. So what happens is this. This often happens in massive construction matters where you have a team of people, either one or three people, right, appointed at the start of the project, but only called upon every 2 or 3 months when there are problems, and to look at the problems, attend to the problems, and come out with a reasoned view on it. And the parties can decide whether they want to follow it, or they want to negotiate a settlement, or they want to find that the dispute board's decision is binding, right? So this very often happens in construction matters. If you click on the hyperlink, it'll take you to a dispute resolution board foundation. I'm the Singapore representative to that board's the foundation, and you'll find a lot of interesting reading material on how dispute board works. All right, so I urge you to take a look at it at your own time. Right now, even ICC, the International Chamber of Commerce, they have got dispute board rules, model agreements, and standard clauses. So when you get a chance, please go take a look at that.